Okay, we are live. I'm just gonna wait for people to get on here. We will get started. Okay, so hopefully you can hear me. For those of you watching, thank you for tuning in. So I see people are slowly coming on here, so I don't want to leave too many people out. So just to get started, I'm attorney Stacy Schlemmer. I'm a family law attorney at Peterson, Berk Cross, and we have offices in Green Bay and Appleton, Wisconsin. I am an attorney licensed to practice in Wisconsin, so if you are watching from out of state, I will be referencing Wisconsin law, so take that for what it's worth. I don't want to mislead anyone. And just to be clear for anyone watching, this does not constitute a consultation. It does not mean I'm providing you with any legal advice. If you want formal legal advice, you would need to retain an attorney to discuss the specifics of your case. I also want to make it very clear that this Facebook Live video does not create an attorney-client relationship, and there is no duty of confidentiality here. So I just want to make sure everybody is aware of that. So as stated on the post for this Facebook Live event, I'm going to be talking about child support during this COVID-19 craziness that we are all experiencing right now. A couple days ago, I did a Facebook Live concerning placement during the coronavirus, and following that event, I was contacted with several questions about child support and what happens if someone is laid off, or if their income changes, or if they lose their job completely and become unemployed. What happens not only for the person who is supposed to be paying child support or maintenance for that matter, and what happens to the person who is supposed to be receiving the child support. So this is not uncommon. It's something that happens all the time where child support needs to be reviewed or addressed because there was a change in circumstances. It just so happens that right now we're going through kind of a crazy anomaly where there's this huge virus going on, and that's affecting people's livelihoods. So what you out there should know about child support, at least under Wisconsin law, is that you can petition the court for a modification of child support in the event that there's a substantial change in circumstances. And that can include a change in your income and a change in your employment, especially if you become unemployed or laid off, or you have to take a lower paying position, something like that. When you file a motion to modify child support, you need to make sure that you file it with the clerk of courts, and then the other party has to be served with a copy of your motion. So if you are the person who has lost their job or has a reduction in income, it's your obligation to file a motion to have the child support or maintenance reviewed. If you do not do that, nobody is going to come banging on your door asking for the child support to be reviewed or changed. So that is on you. And so you are aware, the earliest date that the court can have for an effective date for a change in child support is the day that the other party is served with your motion to modify, because that is when the person is on notice that you are requesting a change. So don't sit on it too long before you take action and get something filed with the court, because you're going to be stuck paying that whatever child support amount you had been paying until it gets changed. Even if they backdate it to the date of service, you're going to be paying that child support that's likely going to be more than what it would be moving forward. So with that motion that I've been explaining, if you want to file that, you can file that with or without an attorney. If you want to file that without an attorney, you just do a Google search for Wisconsin Circuit Court forms, and you select family law forms. You're going to select post-judgment forms, and then you're going to find a motion to modify and then you check the child support box. So there's going to be a motion to modify form, and it's going to have custody, placement, child support, and other as options you can check on it. And you're going to want to check the box that says child support if that's what you're trying to modify. And you fill out that form. You have an affidavit, which is a fancy name for a statement that you file along with that, explaining why you want to have the child support reviewed or changed. And then that's what you file with the court. Once you file it, again, then you have to have the other person served. You can use the sheriff's department. You can use a private process server. Those are usually the options that people will use if they are representing themselves. And then that gets the process started. Now, especially right now, because the courts are so backlogged, because all of the hearings are getting pushed off further and further into the future because the courts are closed for a lot of the family hearings right now, the sooner you get this done, the better, because you're likely going to be scheduling out into May or even June for your review hearing. But remember, the earliest effective date can be the date of service. So the sooner you have the other person served, the better it is for you. Now, on the other side of things, if you're the person who is supposed to be receiving child support or maintenance and you're not getting paid the child support or maintenance, whether or not it's related to the coronavirus outbreak or someone losing their job, if you want to petition the court to modify or review the child support, you can follow those same procedures that I just told you about. If you think somebody's income if the payer's income, for example, has gone up, you may want to petition the court to have the child support reviewed yourself. If someone is not paying child support, the person who should be receiving the support can file a motion for contempt with the court because the payer is not following the court order, meaning that they are in contempt of court. When you file a motion for contempt, you also have to have the motion served on the other party. And when you bring your court action before the commissioner or before the judge, it is basically, if there's an order to show cause filed, which is another way of putting a motion for contempt, is an order to show cause for contempt, the person who is said to be in contempt has the burden of showing why they shouldn't be in contempt. That if they're not paying support and that's backed up by the facts, they have to have a good reason for not paying support. So some examples of a good reason would be that they were laid off, if they had a serious illness, if they simply had no money coming in. Things like that are things that the court will take into consideration. And even if someone hasn't been paying support as they were ordered to, if the court feels they had a good reason for not paying the support, the court can still refuse to find somebody in contempt, but that doesn't alleviate the payer from having to pay the missed support payments. So one way or another, those support payments would still be paid. If the court finds that there was not a good reason for missing payments and that the payer did have the ability to pay and did unreasonably and intentionally violate the court order, then the court can certify the payer for contempt of court, and there are a lot of different sanctions that the court can enter for someone who is found in contempt of court. They can garnish wages, they can seize bank accounts, they can put a freeze on their driver's license so that they can't operate a vehicle. They can even sentence people to jail for not paying support that they're supposed to be paying. There's a lot of specifics that you can get into, and if you wanted to consult with an attorney, whether that's me or someone else around, you can absolutely do that and get more specifics on different things you might want to ask for and what might be more pertinent to your situation. But those are different options that are out there. And unfortunately, right now, with this coronavirus going around, a lot of people are losing their jobs. They're getting hours cut. They're unable to go into work at all. And I've seen a lot of people posting that they're simply losing their jobs, which is a sad situation, but it can't be helped. This is something that's completely out of a lot of people's control. Now, This, in my opinion, if someone is laid off because of the coronavirus and because of all the government shutdowns and things like that, I do believe that the courts are going to say that that's a good reason for not paying child support. That doesn't mean that the person gets out of paying child support. It would be up to the payer to file the motion to modify child support in order to change the amount they're supposed to pay based upon their change in income. So if someone was earning, say, $50 an hour at a good job at a manufacturing plant or something like that, they lose their job. Now they're earning, say, $15, $17 an hour working at Quick Trip or something to make ends meet, and there's no other jobs available. They can't find anything else. The court may choose to modify the child support, which may have been previously set at the $50 an hour level. They may choose to drop the child support down until that person can get back on their feet. On the other hand, the court can say if this person, the payer, quit their job voluntarily, or they were doing something they weren't supposed to be doing and they got, let go because of that, and it just happened to be while this coronavirus was going on, that the coronavirus isn't a get out of jail free card, so to speak, for every situation. If someone has consistently not been paying child support and that hasn't changed because of coronavirus, and somebody, say they voluntarily, like I said, quit their job, or they get laid off because of something they did, and their income goes down, the court can still impute income to someone for what they had been earning if there is not a good reason for the change in their income. Okay, so I want to make sure that that's very clear as well. Someone can't voluntarily quit their job making $100,000 a year and go to flip burgers at McDonald's and claim, I can't pay any more than child support on minimum wage because I'm working at McDonald's. The court can look at what somebody is capable of earning and set child support based on that. So again, it's another situation which is very common in family law where it's up to the discretion of the judge and every case is different. So that's why it's important to know what you're getting into and to have your arguments all laid out before you go into court so that you are speaking clearly and concisely to the commissioner or the judge so that they know exactly what your arguments are and what you're asking for from the court, and then they can make a decision based upon what they're presented with. If you feel that someone who had been making, say, $100,000 a year in a different job and now is all of a sudden working flipping burgers at McDonald's, you would be able to show, because you should be exchanging your tax returns every year. That's by law. You should be exchanging those every year when there's support. You should have the payer's proof of income going back however many years there's been a child support order in place. So you can show the history of what that person has earned year to year. And if it's all of a sudden a drop from $100,000 a year to $15,000 a year, the court's going to want an explanation. And if the payer can't provide a good explanation, the court will impute income to them. I see it all of the time. What statute that I'm relying on, just so you all know, if you want to get some fun, light reading and read through the things that I'm referring to, it's Wisconsin Statute 767.73 is the delinquent child or family support under the statute, and that's what you would be relying on in a motion where someone is not paying their support that they're supposed to be. So if you do a Google search, just do WisStat 767.73 and you'll find it. It'll come up and it'll bring you to the Wisconsin State Legislature site, and it has all of the statutes in there. So if you want to read through all of the statutes, that's where you go. Chapter 767 is the family law statutes. That's the chapter about family law. So anything concerning divorce, legal separation, annulment, child support, maintenance, things like that is going to be under that chapter. So again, for some fun, light reading, you can read through those statutes if you really want to. But that'll give you examples of substantial changes in circumstances that the court can consider if they're going to be modifying a child support order. And just because I was looking at that statute preparing for this live event, just so you guys know, examples that are listed in the statute are a change in the payer's income, which we discussed already, change in the needs of the child. Usually that would come up if, heaven forbid, the child all of a sudden has expensive medical needs or special needs, and the court needs to address that in setting a child support order. If there's a change in the payer's earning capacity, or any other fact that the court deems relevant. So that's one of those fun catch-all provisions. So if there's anything else out there that you think is relevant to share with the court as to why you feel that child support should be changed, that is where you would bring that up. So hopefully that helps. It's under that 767.73 statute where the court can suspend someone's driver's license. That's specifically listed in that statute. And that is if someone has failed to pay support for 90 days and the court finds that the person had the ability to pay and willfully chose not to pay support. So that's the statute you're going to want to be looking at if that's the situation that you find yourself in. If you are a payer who has been affected by the coronavirus outbreak and you've lost your ability to earn income that you had in the past for whatever reason tied to this virus outbreak or to something completely out of your control, then you would want to file a motion to modify child support, like I said, sooner rather than later, because that effective date, they cannot do retroactive child support changes. So if you get laid off, say, today, and you don't file a motion to modify child support for 3 months, you can't ask the court to backdate your child support change to today. It would only be backdated to the day you served your motion on the other parent. Okay, so that's why it's so important to not just sit on that for a while. You want to get that filed right away. And you're supposed to inform the child support agency as well as the other parent or party of any change in your employment or income. So you should be notifying the child support agency and the other party if, heaven forbid, you're laid off or you lose your job for some reason, so that they're on notice that that's going on. So I'd also talked about contempt, and that's going to be under section 767.78. That's of failure to pay. And that's where the person not paying support would need to show the good reason to the court why they're not paying support like they were ordered to. If it's willful and intentional failure to follow a court order, the court will find that person in contempt. And it'll be up to the judge to carry out sanctions like sending somebody to jail, having them fined, take away their driver's license, garnish their wages, garnish their tax returns, or seize their bank accounts. There's all sorts of stuff that the government can do. They don't like it, or I should say the courts don't like it when their orders aren't followed, and they especially don't like it when kids aren't being supported, when the parent who's supposed to be paying support can support them and chooses not to. So those are a couple of things to keep in mind. I have a couple questions here. Let me see if I can read that. So I have a question. Then when they go back to work, does the amount go back to what it was? What if they don't let the child support office know they went back? That's an excellent question. It's somewhat on you to keep tabs. So if you get called back to court because the payer is asking for a modification of child support because they were laid off or they had a change in income, the court will have something in the order. It's typical standard language in all orders that within 10 days of any change in employment, that the payer has to notify the child support office and the other parent. So if there's a change in income or employment, the other person knows about it. The other way you can find out about a change in income is with that annual exchange of tax information. Normally there's going to be in your court orders, whether it's in a judgment of paternity or a judgment of divorce, language that says you have to exchange your taxes every year. What the statutes say is every year you have to exchange proof of income. I typically put that you just exchange your taxes and W-2s every year. I usually put a deadline of April 15th just because you have to file by April 15th every year, except for this year, which is a completely skewed example of how taxes normally have to be filed. But that way it's clear for everybody for the exchanges. It is required by statute. So it doesn't have to be in your judgment of divorce or your judgment of paternity. It's required by statute that you exchange your income information. So I know that an annual exchange on just once a year isn't the best way of judging somebody's change in income, but if they're not providing that information to you, that's when they should be exchanging it. If somebody refuses to provide their taxes annually, then you would file a motion for contempt with the court because they're not complying with the court order, and likely they're not complying with the state statute, which you have to do. So you have that in as well. All right, somebody else is asking, what happens when you try and notify the child support agency about a change and they say they don't care unless the case has enforcement services? That is probably the answer you're going to get from the child support office unless the child is receiving state assistance, meaning Badger Care or housing assistance, daycare assistance, things like that. Otherwise, the state doesn't care. If they're not losing out on any money, they're not going to care. They're overwhelmed with the amount of cases they have to handle that do have state assistance. So if you try to notify, I'm not sure, are you trying to notify the child support agency that child support's not being paid and they're not paying attention? That doesn't surprise me at all because they're backlogged like crazy. But if your child support's not getting paid, you don't have to bother notifying the child support agency. Just file a motion for contempt in order to show cause for contempt, and then it's on the other person to show that they have a good reason. If they don't, the court will find them in contempt and they'll have to pay one way or another. That never goes away. In case you didn't already know it, a child support order or maintenance order can never be discharged in bankruptcy or written off anyway. The only way you get out of it basically is kicking the bucket. You can never write it off in bankruptcy. So it doesn't go away. It doesn't matter if somebody is 80 years old on their deathbed. If they have child support arrears and they file taxes and they get a refund, that will get intercepted to pay on arrears for child support. That never goes away. So like I said, I don't know that I would even bother contacting the child support office if you aren't receiving any assistance. Just file your own motion or hire an attorney to help file a motion for you. When you file a motion to modify child support or review child support, or you file a motion for contempt, that opens the door where you can request income information from the other person via discovery, it's called. So you can request pay stubs, you can request W-2s, you can request a Social Security earnings statement. And if you don't know what a Social Security earnings statement is, you should. It's actually a really cool thing that's out there where ever since you started working and paying into the government for taxes, the Social Security Administration has been keeping track of what you earn every year. So for me, that would start when I was 15, and every year since then, it would show how much I earned every year. And where that comes in handy is if, in that situation I was talking about before, where somebody was working a $100,000 a year job for the past 5 years, and then all of a sudden they quit that and go work at McDonald's saying that's all they can do, the court's basically going to call BS and say, no, your Social Security earnings statement clearly shows that you were making $100,000 a year for the past 5 years. We know that that's what you can earn moving forward. So that's a really good tool that I like to use, and I always ask for a Social Security earnings statement in addition to pay stubs, in addition to tax returns, in addition to W-2s. Because it's something that people can't wiggle their way out of. You can't fake that document. It comes from the Social Security Administration. Okay, so someone is asking, by exchange of tax information, does that mean with the courts or with the other parties as well? So the court's not going to care. They're not going to check in with you. They don't care unless you have a motion pending. Then they're going to ask you to bring your last 2 years' tax returns. When I'm saying the annual exchange of your taxes, that's just you and the other parent exchanging your taxes. Now, if one parent is a primary parent and the other person is the payer, really the only person's income that matters is the payer. because it's primary placement, so the court only takes into account the payer's income. If you have a shared placement schedule, then the court does a different calculation, and it's based upon mom's income and dad's income. So then both parents need to be exchanging their information. It's more important because you may need to do a modification if either parent has a significant change in their income. Hopefully that answers that question. And also, when you do exchange the taxes, make sure that you always get all of the attachments, the W-2s, 1099s, any schedules, because especially if someone is self-employed or has a side business or is cashing in a bunch of stocks or stuff like that, there's a lot of things that show up on a tax return that can be considered income for purposes of calculating child support. So it's important to make sure you don't just exchange, page 1 and 2 of the federal return and nothing else. You need the full tax return packet with all of the attachments. And when I say all of the attachments, obviously they don't need like your mortgage interest statement or something like that, but W-2s, 1099s, if there's an itemized deductions list for businesses, things like that, you're gonna want to get a copy of. What if they stopped paying a month before this pandemic happened? Then you're in that crew that I was talking about before, where you probably want to file a motion for contempt because it sounds like you have somebody who has an issue that's not related to the coronavirus issue with paying. And I don't know if that person isn't paying just because they don't want to pay, or if they're not paying because they don't have a job, or what's going on. But the only way that you're going to get that addressed, likely, unless you can have this breakthrough moment with this person and they all of a sudden just start paying, is by filing a motion with the court. Sometimes just filing a motion and serving the other person is enough of a kick in the pants to get payments to start rolling in. It isn't always. But it's kind of like a demand letter. If you get a lawyer with some lawyer's letterhead on it and it says, stop doing this or else we're suing you, sometimes that's enough. Usually that's enough to just make people stop in their tracks because they get scared and they don't want to get in trouble. If you have someone who's not easily scared off, then you're probably going to have to go through the whole process and you have to go to court. You have to have your hearing. You're going to have the judge or the commissioner decide whether it was reasonable for the person who's supposed to be paying child support to not be paying child support. But I wouldn't let that just sit too long, because if you don't do anything about it and they're just going to continue to not pay, why sit around and wait for it? Just file the motion. If you file a motion for contempt and you win, the court can order that person to pay your attorney's fees and costs of service if you win. So that's something you always want to ask for if you have a motion for contempt hearing and you win. So if you go to court and the court says, payer, you were supposed to pay, you didn't pay, you had the ability to pay, you're in contempt of court, they can order that person to also pay any attorney fees that you have by having an attorney there, or the cost of service, which is usually somewhere around $50, usually $30 to $50. So there's some extra money in your pocket. They don't charge a filing fee for contempt motions because it shouldn't be a burden on the person who has to file a motion for contempt, because it's the fault of the person who's not following the order that you even have to file a motion for contempt, if that makes sense. So I wouldn't sit on that too long. Okay, let's see. How much would attorney fees cost usually? Depends who you're talking to. If you go with an experienced attorney, it's going to cost more. If you go with somebody who just graduated from law school yesterday, it's going to be cheaper. It depends who you're comfortable with. And some attorneys will do flat fees. Some attorneys will do a lower retainer for just, a single, if it's just a motion for contempt and it's one hearing and you're done. Usually that would be a different retainer and likely smaller retainer than it would be for, say, starting a divorce from scratch and going through a whole divorce process where there's going to be multiple hearings. So it's just a matter of, don't be afraid to shop around and price out different attorneys. Feel free to talk with different attorneys. I would normally say meet with different attorneys, but right now a lot of people aren't meeting face to face. So you might have to have consultations by phone right now, but get a sense of who the different attorneys are, find out who you're comfortable with, and then you just have to weigh how much you're willing to pay, what you're looking for, what you're comfortable with. In my opinion, it does experience matters. So I don't recommend you hire somebody fresh out of law school, but hey, I was fresh out of law school about 12 years ago, so I get it. But I at least would want somebody who has a little bit more experience helping me with something as important as that. And it also helps knowing that if you have a good case, an experienced attorney will tell you that you have a good case, and you have to keep in mind, you can ask for your attorney fees to come back to you at the end. The court doesn't always give you all of your attorney's fees back, but they'll usually give you a couple hours at least, so that takes the hit away somewhat there. And when you go in and talk with the attorney, if you retain the attorney on the contempt motion, that doesn't mean that you can't pick their brain about some other stuff. You might have some other issues that you might need to file a different motion that you didn't even know existed or that you needed to file. So there is that benefit of working with a professional as well. So a lot of attorneys in town offer free consultations. My office is one of them. There's plenty of good attorneys in Green Bay and Appleton and in this area. So, feel free to reach out to me, to my office. We have 3 family attorneys in my office alone. And if we can't help you, we've got plenty of other places we can refer you to who are good, competent family attorneys around. Okay. Question for me. Do you travel outside of Appleton and Green Bay area? Yes. All over the place. Basically anywhere in Wisconsin, I'll go. I personally go up to Marinette, Dorr, all the way over to Shawano and Wausau, down to Manitowoc. We go over to Wapaka, Winnebago, Fond du Lac counties. We go all over the place. And a lot of attorneys in town will, you just have to ask. Some just stay right in Green Bay, or some just stay in the valley, but a lot will go other places if need be. Okay, let's see here. What if they stopped paying in January because they got laid off, ran out of unemployment, got a job, never paid, quit the job, got another job, and is now laid off due to the virus? Yikes. I don't envy your situation at all. That sounds awful. The problem is that right now, if they're laid off and there's minimal to no income coming in, that doesn't help your situation with getting money, because you can't get blood from a turnip. However, if nobody goes in to modify the child support order, that's going to sit and collect arrears. And like I said before, you can't get out of it. So if the arrears accumulate any time that the payer, which I assume in your case is the father, if the father's not paying and he ever files taxes, the refund will be intercepted and go towards the arrears. The court can also find him in contempt for non-payment. If this goes on and he's not attempting to find work and he's not doing anything to better the situation to be able to pay child support, and he's just not making any payments, the court can still find him in contempt and require him to make payments on the amount, even if it's just payments towards arrears for a while or whatever. The court can require him to do work search, all sorts of stuff. So the amount won't change unless somebody files a motion to change the amount. So if he just doesn't pay, it's just going to sit and rack up and rack up and rack up. And at some point, you can take him back to court for contempt for non-payment if he just doesn't pay anything. And hopefully, after this virus gets out of here, the economy will bounce back. It was such a good economy for such a long time for the past few years that it was an easy argument to make in court that in this economy, anybody can get a job making $15 an hour. So if people weren't working, the court would usually impute something, usually around $12 to $15 an hour. Now we're in this weird funk and nobody really knows what's going on. We don't know who's going to be hiring for sure. We know that, Quick Trips and grocery stores, places like that are hiring, but it's so much different. There's so much up in the air right now. It's kind of hard to know what the court's going to do with imputing income. Okay. I'm not sure what can you do if your support was supposed to start in January, but with the COVID-19 craziness going on, it's pushed to June. I'm not sure what you mean. So just keep in mind, when you file a motion, whether it's for a temporary order in a paternity or divorce case, or if it's a motion to modify, the court can have the effective date be the date of service. So it doesn't matter if you're in court a week after the date of service or 6 months from the date of service. The court can still backdate it to that effective date. And so if someone, say they were served in January and you don't get into court until June, the court can still order child support to have started back in January. So there would just be back support owed. There'd be like an arrearage balance, and the person who's paying would have to just chip away at that. Hopefully that makes sense. So it doesn't mean that you just SOL. You can still have the effective date back to January, but it just means the person's going to have this big balance they're going to have to chip away at. It'll still be owed. What if the courts are closed in your area and you are laid off and can't pay? I don't know of any courts that are completely closed to filings. You should still be able to file a motion with the courts. I'm not sure what county you're in, if it's a county around here, but I'm not aware of any that are closed completely. The clerk of court's offices, even if they're not open to the public, you can e-file, which means electronically file paperwork as well. And that's another benefit of having an attorney work with you, is we're used to e-filing. We e-file everything. So we don't have to go down to the clerk of court's office and hand them the paperwork in person and pay the filing fee, things like that. We just do everything electronically. As long as it's filed electronically, you get a copy back from the court electronically, and you just print that out, and that's what you would have the other person served with. So you would still be able to do that process now, even if you can't get into court for a hearing yet. Because the courts are scheduling out hearings later and later because of all these government mandates and the coronavirus concerns. So whereas you normally would file a motion and probably get into court within 4 to 6 weeks, now you're looking at probably closer to 6 to 8 weeks. Some of the courts around here are scheduling phone hearings instead of in-person hearings, but obviously the best way to have a hearing is to have it in person so that you can have witnesses or you could have exhibits to show the court. So that's what the courts are trying to do. They're trying to push them out far enough where you can be there in person. That's obviously the best way to do it. So hopefully that answers that question. Like I said, I don't know of any courts that are completely closed to filings. And part of that reason is because of concerns with due process rights and emergency hearings and things like that, that the courts just can't completely shut down. So that's those things. Let me see if there were any other questions that I missed here. I see people are posting questions. So if anybody else out there has any questions, there's no such thing as a stupid question. I promise. I get asked all sorts of questions all the time with this job. But hopefully, this is able to help explain a couple of things to you. Just because of the coronavirus doesn't change how the laws work. I just want to make sure that everybody out there understands what needs to be done, with all of these changes that are happening because of the coronavirus. Because of the coronavirus, a lot of people are getting laid off. Because of the coronavirus, a lot of people are getting unemployment or are completely losing their jobs and unable to work. So I just want to make sure that you guys know whether you're the payer and you need to petition the court to have the child support reviewed or lowered, or if you're the payee, meaning you're supposed to be getting child support and you're not, and there's not a good reason, then maybe you want to file a motion for contempt. I just want to make sure that you're familiar with how this all works. Okay, question. Would I know if he filed a motion to lower? So for those of you who are not familiar with CCAP, get familiar with it, especially if you are one of those detective parents that likes to know, research the other person and see if they're getting into trouble, or their new significant other, see if they're getting into trouble or if they have a criminal record. CCAP is the Wisconsin Circuit Court Access Program. And if you just do a Google search for Wisconsin CCAP, you go on there and you can type in the person's name and hit search, and it will bring up any cases with that person's name, with that name, anywhere in the state of Wisconsin. So you might get, if you put in John Smith, you're probably gonna get 500 results from different counties throughout the state. But if the other person in your case happens to be named John Smith or something very common like that, you can put in their date of birth to narrow it down. You can narrow it down by county. And on there, you can find your case. So if you're a divorce case or paternity case, you can go on CCAP and look up your case, and it'll show everything that's been filed on your case. So it's a really great tool to use. And it's also good, like I said, if you just want to see what the other person's been up to, if they tend to get into legal trouble, that's a good resource, because it'll also show any criminal filings that are out there. It'll show if somebody has gotten, any tickets, they might be on there. So that's a really good tool. That's how you can see if somebody has filed something. So I also do divorces. So sometimes people will look themselves up on CCAP and realize that their spouse has filed a divorce and they didn't even get served yet, but they found that out through CCAP, because as soon as somebody files, it's going to be updated on CCAP. So you can look up your name, or you can look up the other person's name, and your case should show up. If it doesn't, you can call the clerk of court's office and ask them, but you should have your case number. And if you have any of your documents from your case, whether it's one of the pleadings, a motion, a final order, in the top right-hand corner, under the name of the county, it's going to have case number, and it's going to have two numbers, which would have been the year. So it might be like 17 FA and then a number, that full number. So 17 FA 1234, whatever it is, that's the case number. And that's what you would want to tell the clerk of courts if you have to call them because you can't find your case on CCAP or something like that. But that's how you would look up in that information. So hopefully that helps in trying to find out if someone else filed a motion. So you would be able to find it on CCAP even before you're served, and just know that that's out there. But you have to be served with a copy of the motion before the hearing, or they're going to have to push back the hearing, because they have to prove that you have personal knowledge from service of the motion being filed at the hearing, so that you can be prepared with any arguments that you want to make at the hearing. So hopefully that helps. Hopefully that makes sense. Thank you, Jody, for the compliment. Anyone else have any other questions about anything? I'm going to quick check on my page to see if anybody posted any more questions. I don't see any. I had a few from earlier, so thank you for the people who did submit questions. It helps me to know what issues are out there for people and what information you want to know, because I don't always know what you want to know. And that's why I'm here tonight. Do I represent outside of Brown County? Yes, I go all over the state, anywhere you need me. When I first started practicing, I was down in southeastern Wisconsin, so I'm familiar with that part of the state. I don't get down there much anymore, but now I really go down to like Manitowoc, Fond du Lac, over to Wapaka, Wausau, up to Marinette and Dorr, everywhere in between. So we go all over the place. What if I'm on state insurance? Does child support file the motion? They may. So if you're on state insurance, then you would have a file with the child support agency because you're on state assistance, and you could contact the child support agency and speak with your representative that's assigned to your case. Make sure you always ask for the representative assigned to your case. Don't just talk to whoever answers the phone. But you want somebody who's familiar with your case. Tell them what's going on and see if they would be filing a motion. Some feedback that I've gotten from people who've come into my office for a consultation after trying that, they have been told that because of backlogs with the child support agency, they're aware of the problem and they'll be filing a motion, but it might not be done for a month or two. And some people just don't want to wait that long, so then they decide to hire me or hire a different attorney to get things rolling, which I don't blame them, because if you're not getting child support and you rely on that to make ends meet, 2 months is a long time to go without any action at all, without anything even being filed. So hopefully that helps. Calumet County, if you're asked, oh, yes, I practice in Calumet County, yes. And good news, Calumet County is actually going to be getting a second judge, so they're not going to be as backlogged as they have been. So I don't know if you guys heard that or not, but for those of you in Calumet County, that's good news, because right now they only have one judge. So it gets a little backlogged out there. All right. Anyone else have any questions about anything? I guess another thing I didn't think of before, but just general information that you should know is if you're under a shared placement schedule and shared placement child support, make sure that you have language specifying responsibility for variable expenses. If you're looking at me or this video with a look on your face like, what the heck is she talking about? What's a variable expense? Then you probably need to talk to a lawyer or look over your judgment, because variable expenses should be in any order that relates to a shared placement and shared placement calculations for child support. With variable expenses, that's expenses above food, shelter, clothing. So you're talking about daycare, school fees, activity fees, piano lessons, karate class, things like that. As the kids get older, you can talk about prom dress, tux rental, driver's ed fees, AP test exam, testing fees, things like that. Those should get split the same as your placement time is split if you're in a shared placement situation. So if mom has 75% of the time and dad has 25% of the time, that's shared placement. It's not equal shared, but it's shared. And the person with 75% of the time should be paying 75% of each variable, and the person with 25% would be paying 25% of each variable. If you have 50-50 equal shared placement, you would be splitting all of the variable expenses. So that's something you would want to address if you're in court for a modification or review of child support, is to make sure you have that language in there. The law was recently updated within the last 2 years to where now parents are required to have a list of examples for variable expenses in their order whenever variable expenses are part of an order. So if you go back to court and you have something modified and now you're addressing variables, you need to have a list of what's going to be considered variable expenses. And those would include things like I just mentioned, where it's school fees, activity fees, piano lessons, karate class, basketball camps, things like that. So just keep that in mind as well. Anybody else have any questions about anything? Wait for a second here. I don't mean to have dead air. Oh, and I wanted to update any of you who watched the previous Facebook Live about the placement with coronavirus. The Oconto County Family Court Commissioner actually reached out to the state bar members, meaning all of the attorneys, and let us know that in general they are going to be requiring makeup placement time for parents who have missed out on placement during the coronavirus. And again, this is assuming it's for a reasonable reason. So that was good news, in my opinion, to give us some clarity on what's to be expected moving forward. So if a parent is self-quarantining and they can't see their kids because they're self-quarantining, the court has said that they would award makeup placement time for the amount of days that were missed that parent would have otherwise had with the kids. And again, that was in Oconto County. I haven't heard anything from any other counties, but I assume it's going to be similar. And it's like what I said in my last Facebook video or Facebook Live video about placement, that the courts are going to look at what's reasonable, and if it's unreasonable or if there's something that was simply out of their control, like the coronavirus, and they were self-quarantined, they're going to give makeup placement time that's just fair. That's best for the kids and best for the parents in most cases. Somebody had asked if it's going to be the same in Outagamie County. Unfortunately, we haven't gotten any feedback from Outagamie County. I assume that other counties are going to be similar to Oconto with their take on it. They're going to want to make sure that the parents get some makeup placement time. But again, hopefully parents can be reasonable with each other. I know that it's not always the case, trust me. I wouldn't be in business if everybody was reasonable. But if parents can be reasonable with each other during this time and do the makeup placement or do Skype or work out some other arrangement that works for the family as a whole, meaning everybody, then you don't have to worry about going to court and trying to get makeup placement time or things like that. It remains to be seen. We'll see what happens, as we start getting into court for these motions, which the courts are already anticipating are going to be coming in droves, then we'll have to see what the courts are doing. Hopefully that helps. Any other questions about anything? Okay, well, so Skype or other virtual communication counts. It doesn't count for placement unless the other parent agrees that it counts for placement. When I say you should work together and at least offer Skype or some sort of electronic communication, that's so that if a parent is self-quarantining, say they work in the medical field and they're self-quarantining, they don't want to expose the kids, and they just say, you keep the kids, but can I Skype with them, or can I call them every night and say goodnight, or things like that. Work with the other parent. We have enough, electronic means of communication now that it doesn't take much to set up FaceTime on, a computer, or have the kids call, for crying out loud. How long have we had telephones? This is nothing new. You shouldn't be denying the parent who can't have placement this opportunity to just connect with the kids. So that's what I mean with that. Be reasonable. It doesn't mean that the parent won't try to get makeup placement time down the road, and it doesn't mean that you shouldn't give them makeup time down the road, because I think we can all agree Skyping is not the same as in-person placement with the kids, but it's better than nothing. So that's just something that I would propose you do, just to be nice if the other parent can't see the kids. How far out would mediation be scheduled? Mediation for what, I guess? So with talking about the child support and stuff, mediation doesn't get involved at all with financial stuff. So if you're talking about mediation for a placement modification or something, that I have no idea how far they're scheduling out right now. I don't believe that they're doing any in-person meetings, so that's going to be scheduled out for a while. I think in Brown County they have one day a month that they try to get everything scheduled. But that I don't know for sure. I really don't. I haven't heard from the mediation department in any of the area courts or counties. So sorry, I can't help you there. I have no idea how far out they're scheduling. So if anyone does have specific questions about their specific case that they want to run by me, other attorneys at my firm, or just other family attorneys, definitely do that. There's plenty of attorneys in town who offer free consultation like our office does. If you want to call me, my number is 920-831-0300. My information is all available on my Facebook page where you are viewing this live video, so you can look me up there to get my contact information. And right now we're not doing in-person meetings, but we are doing phone consultations. So if you wanted to set up a phone consultation, it's free, it's confidential. It's a 30-minute consultation to at least get some information on what your rights and options are. So if you dish everything to me and I tell you you don't have a chance, don't bother with it, then you at least know not to waste your time, I guess. But I can explain to you maybe some rights and options that you might not be aware of. And that's always my goal. That's why my firm offers free consultations. We want people to know what their rights and options are. We don't want people going into court just completely blindsided and have no idea what's going on. Even if you don't hire us, at least we would feel more comfortable if you knew what you were doing going into court and have some idea of what your rights and options are. So along with me, we also have Angela Bolter and Devin Shanley who do family law at our office. We also have personal injury, criminal defense, and estate planning lawyers at our office. So if you have any questions or concerns about anything in those areas of law, you can always feel free to reach out to us on those too. And with all this coronavirus going on, it's a good reminder to update your wills if you haven't done that. I would be a bad lawyer if I didn't tell you to either get a will or make sure it's updated and current. You don't want to be caught off guard and leave your family in a bad situation without having your estate plan put together. So I don't see any other questions coming through. So with that, I will thank you all for watching. And like I said, if you have any questions, feel free to reach out. You can either shoot me a message on Facebook or give me a call at the office. So have a good night, everyone. Bye.